Mr. Driscoll.
In the course of addressing your lordships on the matters which are set out in paragraphs 111 to 157 of our printed case.
Paragraphs
111 to 157 of our printed case. This is where I began yesterday.
Yes.
So far as the origins of the Mines Working Facilities and Support Act 1923 are concerned, our researchers suggest that it came about as a recommendation of the Acquisition and Valuation of Land Committee in 1919, which was chaired by Sir Leslie Scott, later Lord Justice Scott. And it came about as a result of a concern that there were considerable quantities, mainly of coal, which were being left unworked for the reasons addressed in Section 1 of the 1923 Act. The choice of the Commission as the relevant tribunal came about, it seems, partly to save money. It was a commission that was already in existence, and it had considerable experience of dealing with disputes of this kind in relation to railway and canal companies. Two judges and one other constituted the commission. They also had they were also there to decide certain questions under the Acquisition of Land Act. And so it was obviously decided, as one can see from the Act, that they should decide whether or not the requirements for compulsory acquisition, which it plainly is, in my submission, not only whether or not the requirements should be were satisfied, but also what compensation should be paid. That's
which paragraph are we at now?
We're not, my lord. This arose out of a question yesterday as to how the 1923 Act came about and why the procedure is as it is in the 1923 Act, rather than, let's say, rather than just say incorporating the Acquisition of Land Act 1919, let us say. And my explanation yesterday, which is the best I can come up with, is that there were other questions that had to be decided before a decision to compulsorily acquire the land, or acquire the rights, was made, and it was decided that the same tribunal should decide both whether or not the requirements were satisfied and fix the compensation for the compulsory acquisition of those rights.
Is the committee report in a command paper? Can you give us a reference?
I assume it will be. All that I'm able to tell you at the moment is it's the Acquisition and Valuation of Land Committee, but I believe it's referred to in it is, I think, the paper referred to in Waters. I think that's where you'll find the reference to it.
Can you remind us where Waters is? I'm sorry, I've forgotten which bundle we're looking at. Maybe I've got it here.
It's in bundle 9.
900. I think it's
900.
Yeah.
And if one turns to paragraph 26 in the speech of Lord Nichols,
Oh, yeah.
Yes.
that's the
Yes.
that's the Scott Committee.
Paragraph
26.
26.
Would it be possible for a copy of the committee report to be made available?
Yes, of course.
So Command 9229.
At the end of yesterday, I was taking the lordships through the Petroleum Production Act. There's very little more for me to point out to your lordships in relation to the Petroleum Production Act 1934. But could I ask
I noticed, I think it's page 10, 11 and so forth of your printed case, I mean, there is quite a lot of reference to the terms in which that Act was introduced into the House of Commons. I mean, are we looking at this stuff or aren't we?
My Lord,
Are you inviting us to or not?
My Lord, I am. Yes. They're very short passages. They are passages from the speeches of the relevant government minister in the House of Lords. It was introduced, first of all, into the House of Lords.
And Lord Hailsham, Secretary of State for War, is this it?
The Secretary of State for Air, I think, introduced it, and there was also a speech in support of it from Viscount Hailsham, who was then Secretary of State for War.
Yes.
And what one derives from those speeches, in the event that the Lordships think there is any ambiguity in the meaning and effect, the intended meaning and effect of the 1934 Act, is that it was intended to deprive any landowner of a right to ask for a royalty payment. Royalties was, of course, the obvious word to use in connection with the exploitation of minerals, and to provide compensation for essentially the loss of surface rights on the basis that it was a compulsory acquisition.
That's really, Viscount Hailsham quoted a paragraph 24, I think, isn't he?
Yes.
Is perhaps the clearest example
Yes.
of that.
And then there's the rejection of the amendment and proposed amendment, paragraph 25.
My Lord, yes.
I mean, because the ultimate question surely is yes or no, was it intended that you should be able to get a piece of the action? I mean, that's in effect what it is.
Yes. The questions are quite short. State. First, is this compulsory acquisition legislation? The answer to that question, in our submission obviously, is yes, it plainly is. The second question is, so far as let's use the word compensation at the moment, so far as the compensation is concerned, was it intended that that should be compensation assessed on, let me say, the usual basis, the conventional basis? Or were the words used in the Act, Section 9.2 in particular, Section 8.2 as it became, so clear, this is how we would put it, so clear that the usual presumption that it's just value to owner was rebutted? That's it, really. And so one looks at the legislation, the 1966 Act, and to be read, obviously, in the context of the 1934 Act, because the 1934 Act does amend it in relation to petroleum. Is it compulsory acquisition? If so, is it the usual basis for compensation in the case of compulsory acquisition, or is there, and this is how Lord Nicholas put it in Waters, is there a clear indication in the wording of the legislation that the usual basis for assessing compensation doesn't apply?
Sorry, where did he put that?
That was in Waters. TFL Waters. The passage I had in mind was somewhere, I'm sorry to put it this way, between paragraph 16 and 18.
This is his discussion of value in the Lands Clauses Act.
Yes, it is.
But your proposition is this, an approach to construction, which is that you start from the assumption that that's what's meant, and you have to find a clear indication to the contrary. And I'm just seeing where we get that actually expressed. Well, there's a bit
I'm
of
not
it.
able to.
Well, there's a bit, if I can help you, there's a little bit, a hint of it at least, at paragraph 39 at the end of it. Sound basic principle, subject to statutory provision to the contrary, it should continue to be applied generally. That's the sort of point you're making. I think it's perhaps not quite in the term.
I'm making it. Maybe that, but again, looking at it, I can't find the particular words or particular sentence. But maybe I'm thinking also of what Lord Walker said, my Lord Walker said in Transport for London against Spiros, at paragraphs 11 and 12. Which again is...
Just remind us where Spiros is.
Spiros is in volume 8.
90. Is it? No, sorry, wrong one.
96.
96.
Yeah.
And it's paragraphs 11 and 12 in particular. It's a rebuttable presumption, my Lord says, adopted by the court in the interpretation of statutes concerned with compensation. This is paragraph 11, and then toward the last sentence in paragraph 12. It's only if the principle is stated at a fairly high level of generality that the court approaches the statute expecting Parliament to intend compensation to be assessed on a no-scheme basis. It has much to do with the determination of this appeal. It's essentially concerned with statutory construction. It's not concerned with the meaning of a particular word or phrase, but with the general attitude and expectation with which the court should approach a statute dealing with compensation for the compulsory acquisition of land.
Yes, that's the second time that passage has been quoted. I have to say, having thought about it a good deal, I also, at the beginning of my opinion, expressed full agreement with Lord Collins. And Lord Collins, paragraph 128, referring in particular to Lord Pearson in the Rugby case, does put it much more on the single word value. So
Well, then I...
there it is. I mean, I'm not in a position to recant, but I just think it right to point out that paragraph 128 was one that I agreed with as well.
Well, then, my Lord, I then come back to the way in which Lord Nichols analysed value in his speech. In Waters.
Waters.
Value.
Yes.
Value is open market value.
Paragraph?
The trouble is there's no reference to value in our statute.
No, there isn't. But again, if one approaches it this way, again, if I can ask you to go back to Lord Nichols in Waters.
Well, he begins with value too.
He begins with that.
So which paragraph is it he's...
Paragraph 15 one begins with.
Yes, of course, but he has a sort of translation of...
Paragraph 16, implicit.
Yeah, but this is all under the heading value in the Lands Clauses Consolidation Act.
Yes, it is.
Yes. But he's got the customary jargon bit at paragraph 16.
Yes, in paragraph 16, it's implicit in this open market value.
Yes.
So value means open market value approach. Is the notion that in the customary jargon, the owner will be a willing seller and the purchaser a willing buyer. And indeed, of course, that is the language now to be found in Rule 2 of Section 5. Compensation should be assessed by reference to the price a willing seller might reasonably expect to obtain from a willing buyer. The seller should not... And then on any arm's length, and I have taken your lordship to this, I know, but on an arm's length sale in the open market, a seller would normally expect to realise any enhanced value because of its location.
So that you would take account of the key value in such a negotiation?
Yes.
In the ordinary case?
Yes.
Unless you give a special meaning to value, if value is there.
Yes.
But merely to say, well, what would a willing owner and a willing buyer do, is not enough on its own, is it? Because you get paragraph 16 in answer to that.
Yes.
Namely, you would take account of the key value. The question is what was intended in this statute.
But the same approach, my lord, is taken in relation to Rule 2.
Yes, if we had Rule 2, that would be fine.
Well,
It's paragraph 18 is where he deals with the qualification, and I have a sort of feeling that doesn't really depend so much on what, it's a speciality that arises when you're valuing in this particular context. Is that what he's really saying? It's saying it's implicit in the yardstick of value in the 1845 Act. The next sentence, when granting a power to acquire land compulsorily, Parliament cannot have intended to increase the value of the subject land. That's his basic point.
yes.
And put in that sentence, it doesn't turn so much on the word value as such, as on the fact that this is a compulsory acquisition and what Parliament would have intended in that context.
Yes.
One could put it that way.
Yes.
Well, that of course is, although Lord Walker, I mean, that's how he appears to have seen it in paragraph 12, isn't it?
Yes.
Concerned with the meaning, it's not concerned with the meaning of a particular word or phrase, with the general attitude and expectation with which the court should approach a statute dealing with compensation for compulsory acquisition of land.
Yes, but it's not with respect just Lord Walker's own idea. He does, in paragraph 12, refer to Benyon, and then at 1803 they in turn refer to Lord Dermot. And this, I think, is this is paragraph 12.
Yeah, we looked at Benyon. Then, sorry, what else do you say we're looking at? Oh, Lord MacDermott, I'm sorry, yes, I see.
Yes, this is
well, that's Point Gore.
Taken from Point Gore itself. As stated by Lord MacDermott, it's well settled that compensation for a compulsory acquisition of land cannot include an increase in value, which is entirely due to the scheme underlying the acquisition. Point Gore itself was not concerned with the meaning of value in the 1845 Act. It's stated here as a broad proposition, and that is, in my submission, the approach of the courts, and correctly stated to be the approach of the courts in by Lord Walker in paragraph 12. It's well said that compensation for a compulsory acquisition of land cannot include an increase in value, which is entirely due to the scheme underlying the acquisition. This is the basis upon, as I say, that Point Gore itself was decided. It wasn't decided, and this was the point that Lord Walker observes later in paragraphs 19 and 20. It wasn't decided on the basis of what is now Rule 3, but it was decided on the basis of the general approach of the courts to the assessment of compensation. And so, in answer to my Lord Clerk, I would say that it doesn't turn on value, and that it would be wrong for the court now to say, well, this all turns on a special meaning given to value in the context of the 1845 Act, because that doesn't explain, for example, Point Gore, nor indeed does it explain the decision in Waters and Welsh Development Agency. The first occasion that there was a reference to compensation in compulsory acquisition legislation was by use of the word value in the 1845 Act and previous specific provisions in specific acts. But following on from that, by the time we get to, for example, Point Gore, the courts are considering not the 1845 Act and what meaning to give to the word value, but the principle more generally.
I think I said yesterday that the whole point, the problem about value is it's completely open-ended. You don't know how to approach value until you know what it is you're valuing. You have to have a clear idea of what it is that you're valuing and what the test is which you're going to have to apply. And the bridge, which I think is apparent in Lord Nichols's judgment, particularly paragraph 16, with the words we find in this Act, is that the commonplace or the customary jargon translates value in the way that he expresses it. But one's still left with the question, okay, well, that's what the bargain is you're envisaging, but you're still left with the question is, what is it they're valuing? What is it they're bargaining about?
Yes.
And until you know what it is that you're trying to value, you don't really get down to the roots of what the problem actually is. I think by that rather rambling suggestion, I'm suggesting that it doesn't matter too much what the word value, the word value itself is. You can have another synonym for it, which I think you're saying is to be found in section 8.2.
Yes.
But you've still got to work out what the context is telling you as to what the value is that you're trying to strike.
My Lord, yes. Could I just remind you of what Rule 2 says? And I know my Lord Clerk has said, well, we haven't got Rule 2 here. But if I can just take you, Rule 2 is in many places, but whilst we have waters, if I can take you to paragraph 27.
27 of what?
Of the speech of Lord Nichols.
Yeah.
Again, following on from a recommendation from the same committee. Rule 2, and this I'm simply taking you to this to show you what Rule 2 says. Rule 2 provided that the value of land should be taken to be the amount which the land, if sold in the open market by a willing seller, might be expected to realise. Now, those words can't really be sensibly distinguished from the words we have in section 8, subsection 2. Now, because they would, on the face of it, enable the willing seller to obtain the only value in the land, which is the ransom value, which is obtainable from the oil company. Your Lordship will have to, if the decision is to go against my clients, then your Lordship will have to say that the words used in this case, fair and reasonable between a willing grantor and a willing grantee, are significantly different from the words sale in the open market by a willing seller. And that, in my submission, is just hair-splitting. And what Waters was about was what was the meaning of Rule 2. It was decided by the House of Lords in Waters that Rule 3, which is also, you see, set out at 1312D, Rule 3 was not going to assist. Now, your Lordship might think, looking at Rule 3, well, that's it. The special suitability or adaptability to the land for any purpose should not be taken into account if that purpose is a purpose to which it could only be applied, but applied only in pursuance of statutory powers, of which there's no market apart from the requirements for any authority possessing compulsory purchase power. And now, what Waters decides is that the value to owner principle and the exclusion of the value attributable to the scheme is not founded upon Rule 3. It's founded upon the general principle adopted by the courts, sometimes known as Point Gord. Now, this is the whole meaning, if I can call it that way, of the decision of the House of Lords in 2004. Lord Scott took the view that it was time to get away from Point Gord and the construction of compensatory provisions in a legislation like this adopted by the courts and just construe the language. And that was the reason for his, if I can call it that, dissent. You'll see in the holding, dismissing the appeal, that Lord Scott dissenting. That was the whole reason for his dissent. although going the statutory interpretation route that he favoured, he would have reached the same conclusion.
Under Rule 3.
Under Rule 3.
He would have given Rule 3
Yes.
a wider grasp than it had been down the years construed to have.
Yeah.
But we didn't think it was necessary to do that because Point Gord had taken over
Yes.
where Rule 3 left off.
That's right. And that's because Point Gord applied, even if, let's assume there was no Rule 3, even if the only words were sale of the land in the open market by a willing seller.
What's the relationship between Point Gord and principle and value to the owner principle?
My Lord, I believe that Lord Nichols deals with this in his speech, and I only hope that I'm going to put it properly. In my submission, they are so close as almost to be indistinguishable.
Where is the best statement of the Point Gord principle? I think my Lord Walker describes it as an imprecise principle at some point.
Well, I mean, in fact, paragraph 42, Lord Nichols surely says, line 3, important to keep in mind, the Point Gord principle is not a reference to principle separate and distinct from the value to the owner principle. It's no more than the name given to one aspect of the long-established value to the owner principle.
Yes. So
And I think 64, if I may say so, is the other place to look in his speech. Line 3. Under the value to the owner principle or the Point Gord principle, whichever nomenclature is preferred, pressing need to be disregarded, etc.
yes, I was going to refer, my Lord Clerk, to paragraphs 36 and
36.
yes, 36. This is the value to.
What I don't really understand is where Lord Nichols goes on and says, but a strip of land may have a special value if it is the key to the development of other land. In that event, the feature of the land represents part of its value as much for the purposes of compensation as on an actual sale in the open market. So how does that proposition fit into all this?
Well,
And it is part of the market. Isn't, it's because of the scheme point. It's not really got anything to do with the market. The truth is that in the market, it has this extra value depending on who the buyer is.
Yes.
Of the way leave or whatever.
That approach, in my submission, would be wholly inconsistent with the decision of the House of Lords in 2004.
Yeah, but I just don't quite understand how he fits in the last part of paragraph 64 with the rest at the moment.
That is
that's a pre-existing value for development other than under the scheme.
yes.
Lord Nichols goes on to quote from Lord Justice Mann in Batchelor in 65, which it does seem to put it quite clearly.
Yeah.
Yes.
I think I quote that bit too, actually. I think.
Are we leaving the point about Hansard? Because I just have one technical point to raise with you, Mr. Driscoll. I've been checking your paragraph 25 in your case, in which you refer to the proposed amendment to the 1934 bill. And footnote 12 refers to column 1944 of Hansard. In fact, what you've reproduced is the written answers, which have nothing to do with this at all. I wonder whether somebody could have another look at page 1944 and find us a page where the government did actually successfully oppose the amendment, because the page that's there doesn't deal with this.
Yes.
The other point I just wanted to be sure about is that the amendment that was being proposed wasn't actually targeted, as I understand it, specifically at ancillary rights. It looks as though what was being asked for was some kind of royalty
Yes.
by the surface owner. So one imagines the person on whose ground a well, or from whose ground a well is sunk. And the idea was you should simply get a royalty because it's your the oil underneath your ground that's been taken away. I think that's what was being asked for, and you say was rejected.
That is certainly my recollection. I think your Lordship is right about that.
Which
We'll
volume
certainly
are these
provide your Lordships with the right, or certainly with the passage that we have in mind, if we haven't done so.
Right, well, it's volume 13, and the particular tab is 154, and my problem is that I think the last page of that is dealing with something entirely different, and I can't actually see anything on that final page which relates to what you're asking us to do, to look at.
My Lords, yes, we will deal with that. Can I come back to Hansard? There is a photocopying point which I want to deal with in relation to that. I wasn't going to deal with it now, but I might as well. But can I also point out to my Lord Clerk that the principle of Point Gord has also was also described by my Lord Brown in paragraph 125 of his speech.
Yes.
The principle is that compensation for compulsory purchase cannot include any increase in value which is entirely due to the scheme underlying the acquisition, the so-called Point Gord rule or no scheme rule.
What it's got nothing to do with, to my mind, however, is value to owner. I mean, I quite see that is the principle.
Yeah.
And it's a sort of...
Well, value to owner means what it's worth to the owner, ignoring the scheme. And in Bachelor...
But obviously, if you introduce an artificial proviso, like ignoring the scheme, then so be it.
Yes. Well, the question in this case is whether or not the words used should persuade the court to construe compensation differently to the way the courts have construed compensation in every other, I think one can put it this way, every other compulsory acquisition context.
In the graveyards case, it's put in this way: the Metropolitan Board will be able to apply the land to purposes which will give it an increased value, but that is no loss to the rector. He has lost nothing by the land having been taken, although they may have acquired something which may prove a gain. I mean, that is also essentially no scheme as well, isn't it?
Yes, it is.
But it's also authoritative value to owner.
Yes.
Which tab is that in?
That's 92 at page 42.
Thank you.
Page 43.
42.
42. Volume 8.
Volume 7.
Can I just ask you to turn...
It's volume 7, I think, 92.
Eight.
Oh, sorry, wait, volume 8.
Eight.
Stepping.
Yeah, I mean, that's the principle on which you're relying.
Yes, and we say it's a very well-established principle. It might strike one as odd if one was coming to it new now, but it's been around for a very long time, and it was certainly around in 1923 and 1934. And I've taken your lordships to cases in which it's been enunciated. South Eastern Railway, and in Naylor and Benzin refers to, which of course 1950 case refers to earlier decisions in which the principle is established. My Lords, my Lords, my copy, if I can ask your Lordships to turn to volume 13. This is a housekeeping matter,
yes.
really, rather than a matter of substance. So the passage is useful. Volume 13, tab 154.
Yes.
Lordships, of course, when your Lordships have read these passages, I hope your Lordships will have to be satisfied that they satisfy the appropriate test for being taken into account. This is the 154. It contains, first of all, I'll just put it in context, on page 662, or column 662, the explanation for the Petroleum Production Bill of the Secretary of State for Air, the Marquess of Londonderry, and that runs for several pages and we've identified the passages which we ask your Lordships to read. If I can then just ask your Lordships to turn on through that same tab to to column 691 and 692. This is the speech of the Secretary of State for War, Viscount Helsham, as one can see at page 688. And this is the housekeeping matter. My copy of it is very difficult to read.
Yes.
And your Lordships is also... this is a convenient moment for me to do this, but to hand up to your Lordships, therefore, clearer copies.
Well, thank you very much. Yeah.
You want a clear copy, or was yours clear?
Nothing short of a Viscount.
Is this the right page? Yes, and it's page 691. And it begins with the passage, "Now it is said, my noble friend Lord Peel used this phrase several times, you're not compensating the owners for the value of the oil, which is under their land."
Sorry, I know the column. Which part of the column?
It's 691.
I know the column. Which part of it?
It's the very beginning.
The very beginning.
Well, it's the first paragraph, isn't it? First full paragraph you were reading from.
Yes, now it is said. It's
Yes, the first full paragraph,
Yes.
a third of the way down. Thank you.
You are not compensating the owners for the value of the oil which is under their land. It's quite true, we're not.
Or for that matter, for the value of oil which is under their neighbour's land.
Yes. And then in the next paragraph down, in the cases with which this bill deals, there's no value at all today in the possible oil rights and the chance of finding oil under the soil. We've been careful to provide that where in any particular place arrangements are made or asked for the sinking of wells or for boreholes, or in any way interfering with the actual rights that exist, interfering with the surface rights, there should be paid not merely full compensation in the sense of the full market value, not merely full compensation for any loss or amenity value, but in addition to that, it's expressly provided in the bill that there shall be an addition of 10%, because the acquisition is a compulsory one, and the owner may not necessarily desire to realise that asset, so that we are careful to give full compensation in every case. And that's full compensation in my submission for any loss or amenity value. Any loss of amenity value, yes, I'm sorry, of amenity value, that should read. So all we do is say that before there's any value established, before any vested right is created, that the oil, if it exists, which nobody knows, should belong to the state in future. Any interference with the rights of property on the soil or with the value of the property under which the soil is situated should be truly compensated for to the owner whose property is interfered with. So no compensation for the value of the oil below, but compensation for any loss of amenity value in the land. So far as the speech of the Marquess of Londonderry is concerned.
So that's the earlier speech.
That's the earlier speech. We've again marked the passages, but if one looks at column 685,
685.
665, I'm sorry.
665.
665, left-hand column. That is the passage of both sides of both columns that we rely on. The difficulties are real, may be gathered from certain expressions of views, and that all complains about the difficulty of establishing title and ransom values. And then at 666, the first full paragraph, if a search for oil in this country on an extensive scale is to be secured, and if results are to be obtained within a reasonable period of years, there are three main requisites. The first of these is the grant of exclusive rights. The second is the provision of machinery through which it will be possible to obtain facilities to enable necessary operations to be carried on where those cannot be secured by voluntary means. And the third, a clear determination of the position in regard to royalties. And then later on, some 15 lines down, as regards the first point, the views expressed by the oil industry make it clear that the position in regard to royalties is one of the principal factors which has hampered the search for oil in this country. And that's one of the reasons for the proposal. And then whilst Lordship has this, there's a reference in column 671, left-hand column on the page. A reference there to the Mines Working Facilities Act. Yeah.
Is this the bit that is relied on by the appellants, in part? I mean, that they rely on the same speech, I think, to show that you don't, so to speak, you're not entitled to simply put in these deviated wells without any permission at all, because there it is, this legislation was enacted in the recognition that you would have to get these additional permissions. Is that right?
My Lord, no, I don't believe it is. I think the passages relied on by the appellants is in a different tab and is concerned with the government's understanding of the meaning of the word land. I think it's tab 155. Yes, 155. Yes.
Yeah.
And there the understanding was that land includes minerals.
Yes.
I'll come back to this.
I see.
I think that's the passage they rely on.
Thank you.
And the other passage that, whilst we're looking at this, is tab 156, and this is from the debate on the bill, which is the House of Lords bill in the House of Commons. And here, this is the President of the Board of Trade, Mr. Runciman, column 217, bottom of the page. The next point which I'd like to examine is this: is there any new departure in the steps which are now being taken? There's only one new departure, and that is the transfer of these royalty rights to the Crown. And essentially, the argument for Bocardo is that the landowner, the owner of the land above the reservoir, is still entitled, in fact, to ask for a royalty. And then, yes, then we've identified some other passages. which perhaps...
There's an explanation for the 10% in column 218, just below halfway down, isn't there? It's about 10 lines into the second main paragraph on the page where he says, we've therefore provided that compensation shall be paid, giving an additional allowance on account of the compulsory acquisition.
Yeah, again, it's put in terms of subjected to disturbance, yes, disturbance. It's only right that he should be compensated. The question is to what extent he should be compensated. Yeah. The view that we've taken is that in making a departure of this kind, we ought to rather on the side of generosity, provide that compensation be paid, giving an additional allowance of not less than 10% on account of the compulsory acquisition of the facilities asked for. So, what is quite clear from reading these passages in the speeches, and we hope that the selection is a fair one, but we've concentrated only on the speeches of the government, this is a government bill, make it clear that they were intended to stop the practice by which landowners could ask for royalties, that, by reference to the value of the petroleum, and compensate the landowners simply for, but importantly for, any disturbance in the enjoyment of their own land, and do so generously. If your lordships were to decide that the language used rebuts, if I can put it this way, the ordinary presumption as to compensation in compulsory acquisition cases, and it's quite clear that the government regarded this as, the ministers regard this as compulsory purchase legislation, then this will be, in my submission, defeating the intention as it emerges from the passages in the speeches to which we referred.
I see they contemplate going down to 10,000 feet, column 1615. About 12 lines down.
Yeah.
Oh, yes.
It looks as though that's a comment on what was being achieved at the time.
Yes. We informed the Court of Appeal, there was no evidence about this, that at the time deviated drilling was not known within this country. It's a later development. You went on, set up your oil rig, and you drilled straight down. But it doesn't affect matters, because even in that case, if the view is that the landowner is entitled to the equivalent of a royalty, a share, a slice of the action, then he'd be entitled to that in relation to the oil rig. You can only put the oil rig on my land if you pay me 12.5% of the revenue. That, in any other language, is a royalty. Well, my lord, I was taking your lordships through the Petroleum Production Act, and
yes, we got as far as 1934. So far.
Yes, we got as far as 1934, and I was taking your lordships, and this you'll find in volume 2 at tab 14. And take you to letter B on page 322. This is 32B. And 32C, you can see also that the principle is established. Again, very common to the approach in the 1845 Act. So far as costs are concerned, compulsory acquisition, the costs in connection with the application shall not be ordered to be paid by any person from whom a right is sought to be obtained. So the landowner is never going to be asked to foot the bill for a dispute over compensation, and the costs so incurred by each such person shall, unless the Commission is satisfied that an unconditional offer in writing was made by the applicant to that person of a sum as compensation, and again I've emphasised more than once the word compensation, equal to or greater than the amount of any compensation awarded to him by the Commission, be ordered to be paid by the applicants. So they will get their costs. They will never have to pay the applicant's costs. They will, however, not get their costs if the applicant has made a better offer. A Part 36 offer, as we would now call it. And then, your Lordships can see in Section 6, there is provision for the Board of Trade, before granting a licence under this Act, to make regulations prescribing a number of matters, A, B, C, and D, model clauses which shall, unless the Board think fit to modify or exclude them in any particular case, be incorporated in any such licence. And then 2, any regulations made under this section shall be laid before each House of Parliament. And so model clauses are implemented by way of statutory instrument. And then the only other provision which is relevant, but not to the matter that we're now considering, is Section 10.3. Nothing in this Act shall be construed as conferring or enabling the Board of Trade to confer on any person any right which he doesn't enjoy apart from this Act to enter on or interfere with land. And I just ask your Lordships to turn back to tab 13, noting the words to enter on or interfere with land, and notice that in section 2 of the Petroleum Production Act 1918, which was a dead letter by this time because it was of so little use, the proviso to section 2 subsection 1 on page 385 is that provided that nothing in this Act shall be construed as conferring on any person any right to enter on or interfere with land for the purpose of searching or boring for or getting petroleum, which he doesn't enjoy apart from this Act. And then it went on to say, or shall prejudice or affect the rights, if any, of any person interested in any land in respect of petroleum gotten through or from the land in which he is so interested. Those final words did not reappear in the 1934 Act. That then is the Petroleum Act of 1934. And perhaps I can ask your Lordships just very quickly, because your Lordships have been taking this, to turn to the 1966 Act, the Mines Working Facilities and Support Act, which your Lordships will find at the back of volume 1.
So where do we find it?
It's the very last tab. It's tab 11. And here you can see that as in the 1923 Act, but now it's expanded in a sense, but restricted in another sense because it doesn't apply in every respect to coal, which has by this time been nationalised. The grant of working facilities is set out. So you have a right to work minerals which you don't own. This is set out in various paragraphs of the table, which applies to any minerals other than peat cut for purposes other than sale, which would therefore apply to coal. But then there is paragraph 2 does not apply to coal, but otherwise it applies to all minerals. As you can see, the government did not take the view that minerals in the 1923 Act included petroleum. And then one can find in paragraph 5 of the table something different. So paragraphs 1, 2, 3 and 4 enable a company to acquire, an applicant to acquire, rights to work minerals paragraph 5 is not a right to work minerals, in effect to own them and sell them, but it's an ancillary right, and it's an ancillary right only, of course, which the 1934 Act is concerned with. An ancillary right may be conferred on a person having the right to work minerals, so you've already got to have the right to work minerals. Those words are amended for the purposes of petroleum, who is working or desirous of working the minerals either by himself or through his lessees, if the right is required in order that the minerals may be properly and conveniently worked by him, and the proper and efficient working of the minerals is unduly hampered by his inability or failure to obtain that right. So this is what any oil company would have to establish. They would have to establish that they need the right in question in order to properly and conveniently work the oil field, and that the proper and efficient working of the minerals is unduly hampered by an inability or failure to obtain that right. And of course, economic considerations will figure there. Then the ancillary rights are defined in section 2, but they of course cover all sorts of minerals. In section 3, again, I know you've been taking this, so I'll take it very quickly. Section 3, there are limitations on the grant of rights, and an important one, but not as Mr. Gaunt accepts, a problem in this case, that you have to satisfy the court that the grant is expedient in the national interest. The very existence of the 1934 Act would seem to satisfy that requirement in respect to petroleum, but then you also have to show that it's not reasonably practicable for any one of a number of reasons, or 4 reasons, to obtain the right by private arrangement. And section 4 requires the applicant, first of all, to obtain the permission of the minister, the relevant minister, currently the Secretary of State for Energy and Climate, to make the application to the court. In fact, it's the minister that refers the application to the court. And then the court is there to decide if the requirements are satisfied, and the compensation provision is set out in section 8.2, as you know. In my submission, this is a piece of legislation which is designed to achieve a public interest in having minerals worked rather than unworked. In the case of petroleum exploited rather than left unexploited. And it is quite clearly compulsory purchase, because the right will be granted even though the landowner does not want it to be granted. It must, in my submission, be compulsory acquisition legislation, and indeed that's recognised in the Petroleum Act itself. What I propose now to do, if I may, is to quickly take your lordships through the cases. Time does not permit, and you would not want me to spend much time on doing this, but if I may just...
And the proposition for which you're doing this is what exactly? In the cases on, and we've been looking at some of them already on value.
Explaining, for example, in the case of Markham, what
yes.
you can and cannot get out of Markham,
yes, I follow.
And the distinction, which in my submission is important, is between a case where compensation is being assessed as part of compulsory acquisition and a case where the right acquired is a right to work the minerals, as opposed to an ancillary right. So the first of the cases on which the appellant relies, and which Mr. Justice Peter Smith also relied quite considerably, is Markham Main Colliery. We say it's of no real help to your lordships at all, really, but your lordships have seized the point. It's a question of statutory interpretation. how the Railway and Canal Commission might have viewed it in 1925 in the context of a case complicated by the fact that it was copyhold land is not in our submission. We're going to assist your lordships, but I would like, nonetheless...
This is volume 6, tab 68, I think. Is it right? I'm quite sure we're looking at the right thing.
No, your lordship is right. I've noted it as 70, but I'm wrong. It's 68.
It's 68. Yes.
This, if I can take your lordships to the end of the decision of Mr. Justice Sankey, which you'll find on 258. You will see that he says in the final paragraph, before Mr. Tyndall Atkinson concurred, that the conclusion of the whole matter is this, that the whole of the application is granted. That is to say, the right to work the minerals, together with the ancillary rights and way leaves, what I might call non-manorial coal, and so forth. So, as far as the freeholders are concerned, the royalty will be £20 for the Barnsley and £16 for the other seams, the colliery company to bear the liability for damages for subsidence. In respect to the copyholders, and this is what the issue was, in respect to the copyholders and Lord Fitzwilliam, the Lord of the Manor, the royalty payable will be 3 3/4 old pence per ton.
3 farthings.
3 farthings, yes, I knew we got it wrong. 3 farthings for the Barnsley seams and 3 old pence per ton for the other seams. The copyholders to have 1/3 and the Lord of the Manor 2/3, and reference is to be made in the minutes of the order as to how this payment of £10 per acre for liability for substance be worked out. So the price fixed for the right to work the minerals was, so far as the copyholders and the Lord of the Manor, Lord Fitzwilliam, was concerned, 3 pence and 3 farthings for the Barnsley seams, and otherwise 3 pence. So that was, if you like, the Section 8.2 price, or Section 9.2 price. Now, it was a right to work the minerals, not a right to access them. It was a right to actually, if you like, work them in the sense of having the same rights as a lessee might have or an owner might have.
You mean take them away for sale? Take them away for sale?
Yeah. And so the Section 9.2, Section 8.2 price, and there doesn't really appear to be a dispute about it, was the figures there, 3 and 3 pence and 3 farthings. However, so far as the asset was concerned, the coal, there were 2 persons who had competing interests in the asset, the coal. On the one hand, there was the copyholder who had the right to possess the coal, rather like a leaseholder, a tenant. And on the other hand, there was the Lord of the Manor who owned it, rather like a freeholder or a landlord. And the real dispute was between those 2 groups. On the one hand, the copyholders who said, well, we possess this coal, and therefore we're entitled to share in the 3 per ton. And the landowner who said, it's my coal. And the issue for this tribunal was how that 3 was going to be divvied up between the copyholders on the one hand and the Lord of the Manor on the other hand. And as you can see from the passage that I've just read, they decided at the end of the day that the copyholders were going to get 1/3, they were going to get 1 penny, and the Lord of the Manor was going to get 2. Now, this exercise was not, in my submission, a Section 9, subsection 2 exercise at all. The Commission fixed the price of threepence as the price that the coal company would have to pay to work the coal. And then it had to decide, and this has got nothing in my submission to do with a willing grantor or a willing grantee, they then had to decide how the threepence was going to be split, divided up between the two competing groups who together made up the grantor. And so, whilst it is no doubt the case that they may well have referred at some part in the decision to arriving at a figure which is fair and reasonable, this was an investigation as to what would be fair and reasonable, if I can put it this way, in a free and unrestricted negotiation. It's not a Section 9, subsection 2 negotiation at all. It's how, because there's a dispute between the two persons who together make up the grantor, how you're going to resolve that dispute.
I'm looking at page 257, left-hand column, about two-thirds of the way down to the bottom. There's the 50% rule. Was that the issue, whether that was the right division here? And as you can see, that was departed from.
Yes.
Are you saying that was the real point, that lots of people deal with these things and there's a sort of standard figure of 50% each? But was that the right one to use here?
The question was because
it's explained in a couple of paragraphs before, the paragraph beginning, then, that being so.
Yeah. Copy holder was asking a sum of money which the landlord said was too much.
But you'll see from that passage that the issue there was how they were going to, how the copy holder and the landlord, who together made up the grantor, they were on that side of the equation, neither of them was the grantee, how they were going to share the proceeds. And an established rule, apparently in 1926, was the 50% rule, 50-50. But then the tribunal heard evidence and argument, and of course customs varied from different parts of the country as to how the share would be made. They then considered whether or not to apply the 50% rule or not, and so later at the foot of that column, although the 50% rule was a huge rule, it was by no means a universal rule. Told of cases by experienced solicitors, had to deal with hundreds and hundreds of cases of this character. In their experience, it was a matter of bargaining. And although 50% was a usual term, it was not universal. They'd known of cases where it was 30%, 70%, and so forth. And then you can see, and you were taken to this passage, it's the column, the right-hand column on page 257, that Sir Arthur Colfax, arguing on behalf of the Lord of the Manor, said that he would accept 20%, but not half and half, but 1/5. And so the issue was it going to be 20% or 50%? And having considered all the matters and the evidence, the tribunal decided it was going to be 1/3 and 2/3. But this, although this is in the context, of course, of an application under the Mines Working Facilities and Support Act, 1923, it is not, in my submission, an exercise being carried out under Section 9, subsection 2. It is deciding, if one likes, what is fair and reasonable so far as the division of the royalty payable by the grantee of the right, how the division of the royalty is to be made as between the persons who together make up the grantor.
You say there wasn't any dispute as to how much the grantee, I mean the landowner and the copyholder together are grantor, but you say no dispute as to how much the grantee should pay?
Yeah, the passage, that is what I'm saying. The passages that you're looking at are not directed to how much the grantee had to pay, the threepence, but how that threepence was going to be divided between the grantor.
I'm so sorry.
I'm so sorry.
No, please.
I was going to just ask on page 258, it probably has nothing to do with this case at all, but simply to understand, why were the freeholders being paid either £20 or £16, which I understand it is an acre, and the lord of the manor and the copyholders were getting a royalty of 3 pence odd per ton? Can you give us any explanation of that?
The frank answer would be no, not at the moment.
Don't waste too much time on it, but it is very puzzling. But
Yeah.
I can't see anything explaining why it was dealt with in two quite different ways.
Figure
No,
per ton.
but as I say, the relevant passages that your lordships have been taken to, and Justice Peter Smith and the Court of Appeal were taken to, are not, in my submission, directed to how you value a right for the purposes of Section 8, subsection 2, as it now is, but how that price, or that amount of consideration, be the appropriate word here, is to be shared between the two persons who make up the grantor. That is why, in my submission, this case is of no use. There are a number of reasons why it's of very little use to your lordships, but this is why it's of no use to your lordships in deciding.
I mean, the grantee is getting a substantial amount, paying a substantial amount, but the reason for that is because he is actually getting the right to work the minerals, i.e. he's actually getting the minerals.
Yes. My lord, just to
I mean, the
to
minerals
clarify.
are being, the property in the minerals is going to go to him. Is this right or not?
My lord, not quite. In this case, the right to work the minerals, if one turns back to 253, and take the third paragraph, the minerals. The minerals which are the subject of the application consist of the Barnsley bed and all other seams of coal lying below a depth of 300 yards from the surface indicated on the plan attached to the application. Originally, the surface under which it was desired to obtain these rights was about 132 acres. But since the application, negotiations have been entered into and successfully concluded with regard to certain parts of the surface. And the application now is in respect of about 110 acres, of which 50 are freehold. Now that's the £10 an acre. There's 50 acres which are freehold, and 60 are copyhold. And it's the copyhold, the 60 acres which are copyhold, which give rise to the 3 per tonne.
Yes. I gather from page 256, left-hand column, about 3/4 of the way down, that what they were doing was applying a sort of standard Yorkshire way of dealing with these things, and it's done on the basis of a foot per acre. And that takes account of the substance risk as well as the extraction.
Yes.
It just seems to be practice there, and there didn't seem to be too much of a dispute about that. And as you say, the real argument then concentrates on the division between the copyholder and the landlord.
Yes.
Well, we don't have a great deal of time, Mr. Driscoll. I mean, it's fascinating to go over these cases.
Yes, I never sort of pretend that your lordships would derive much assistance from remark and Corrie, but I thought it right that I should explain it as in my submission it is to be explained. The second case relied on by Bocardo is Mercury Communications. We made our submissions in relation to Mercury Communications, but in short, Mercury Communications is there, but it's concerned with a different statutory code.
So are you saying it's right or wrong?
Well, my lord, in my submission, it doesn't matter because one's concerned with maybe I will have to take a lordship. It's concerned with the wording of a different statute altogether.
I mean, I thought one way of putting the issue before us was Mr. Pete Gibson right or was Judge Haig right? But that's not a correct way of putting this.
No, I wouldn't, my lord, put it that way. They both could be right in their own little fields.
Right.
Judge Haig could be right in relation to
But he said,
the telecommunications
no,
code.
he said Mr. Justice Peter Gibson's wrong.
This is
Well,
tab 70.
he is wrong to say that Mr. Justice Peter Gibson is wrong, but the point that I'm making, that so far as his own decision, which isn't concerned with the Mines Working Facilities and Support Act or petroleum, it's to do with the telecommunications code, is distinguishable. Perhaps we ought to just very quickly look at it. After all, it's in tab 70. And if one turns to page 15 of 25, you can see that there were a number of differences. His Honour Judge Haig didn't think they were decisive, but they're listed in what Mr. Hobson had to say.
But it is a case of compulsory acquisition, isn't it?
No, that's in my submission. That's not how it was said. Well, maybe it is, but that's not how the judge looked at it.
No.
Well, he's saying at page 16 of 25, where we see his conclusion, that it's quite untenable to suggest that the wording of section 88, subsection 2 of the 1966 Act was the background to this.
Yes.
And he's saying that. And therefore you apply the code without regard to compulsory purchase principles. And then he looks at willingly and fair and reasonable. But I'm not absolutely clear at the moment why he is able to discard the compulsory purchase approach so easily.
No, but before the, if we go back to 15, page 15 of 25, he sets out a number of differences. For example, one, the legislative provisions use different wordings. Two, the case concerned the exploitation of petroleum which would be nationalised without compensation. A licence confers a monopoly, no model clauses. Licensees can acquire rights compulsorily, so in effect can an operator under the code. The criteria for the grant of rights are rather different. In the present case, there's no addition for the acquisition being compulsory. The particular phrase is compensation or consideration, and a willing grantor and a willing grantee in section 8.2 of the 1966 Act are materially different. However, I agree with Mr. Aikens that these differences would not by themselves be of sufficient significance. But those are the differences. He then submitted there were three reasons why the compulsory purchase principles cannot properly be applied to paragraph 7.1a of the code. First, he drew attention to certain provisions of the code where the statutory provisions as to compulsory acquisition are expressly incorporated into the code. Going down to the next one. Second, he drew attention to the code concerning telecommunications under previous acts, which was replaced by the code. And then he referred to those provisions. And then he referred to other statutes by which public utility companies have been given rights to acquire rights compulsory. In all such cases, the compulsory purchase legislation and the land compensation being expressly incorporated. One can make that same point here, I suppose. What I would make our case in relation to this in paragraph 155 of our written case, but the point that the points that I would make are these. First of all, Judge Haig was interpreting a different statutory code, contained different words. he may well be right in the context of that particular statutory code. Secondly, insofar as he was suggesting that BP and Ryder was wrong, he himself was wrong. But he didn't have the benefit of the House of Lords decisions in Waters and Transport for London, nor does he appear, although he must have had it in mind, he would have known about it, nor does he appear to have factored into this the scheme which is contained in the Petroleum Production Act 1934. Essentially, for those, finally, I suppose, the point we make is that the decision of Mr. Justice Peter Gibson is, and now the Court of Appeal, is to be preferred.
I'm sorry, the paragraph on page 16 under the heading Conclusion on Application of Compulsory second sentence, it seems to me the idea that Parliament must have had the wording of 8.2 of the 66 Act is what we've got.
Yes.
And he seems to be saying, well, if that was the position, then Mr. Hodgson would be wrong.
Yes.
So that would seem, therefore, to be saying, you know, that under 8.2, you win.
Yes. But that is because, I don't shy away from this, that is because he was himself unhappy with the decision in BP and Ryder, but regarded BP and Ryder as a decision that was binding on him.
I see.
Yes, I mean, his own view is on page 14 at the bottom, on the BP and Ryder points.
Yes.
And then
Yes,
he records
yes,
Mr. Aiken's argument as essentially your argument, I think.
Yes. It is. But, again, this is...
And he also held that the premium value of the right to lay the ducts was pre-existence to the acquisition of the right.
Yeah, in this respect, we're left with really saying this. I mean, I've put forward the arguments already as to why the assessment of compensation in this case is to be determined in accordance with the established rule in relation to compulsory acquisition. My submission to Justice Peter Gibson and the Court of Appeal were right. You can see that His Honour Judge Haig did not like the decision in BP and Ryder, but at the end of the day he was able to distinguish it. And he was able to distinguish it on the basis that the code that he was faced with was differently worded. But there it is. It doesn't, in my submission, detract from the arguments which I've already put to you on the basis of established authority in relation to Point Broad. And of course, the judge didn't have the benefit of Waters in particular. He did, perhaps whilst we're looking at it, he did make the observation that 232E.
What?
At 232E, I'm trying to find where in this rather fantastic copy of the
6 or
case.
7, yeah.
Yes, it's page 7. Yes, page 7.
Sorry, I'm not quite sure where we are. We're still in Mercury, are we?
We're still in Mercury.
Yes.
It's page 7.
Right.
And it's just before outline of rival arguments, that paragraph.
Oh, yes, yes.
it follows that the only financial term which can be imposed is the payment of, quote, consideration. That word, to my mind, suggests that the rights to be granted have a price, irrespective of any detriment to the grantor. The word is used in contrast to compensation in paragraph 7.1b and 7.2, which suggests loss or damage to the grantor for which he should be compensated. We, of course, as I pointed out more than once, in the context of the 1934 Act, only have a reference to the word compensation. And indeed, the same point, as His Honour Judge Haig makes there, is also made in paragraph 35 of the appellant's written case. Turning then to F.R. Evans, Leeds Limited and English Electric Company Limited, I would simply say that that is not a compulsory acquisition case.
There's Mr. Justice Donaldson.
Yeah.
Donaldson.
It's just the way in which you would construe a rent review provision. And if there is no compulsory acquisition point, value to owner point gored, then clearly the result in Evans and English Electric Company is the right result. It's a free, untrammeled, unrestricted negotiation. And so, quite simply, it wasn't a point gored case. Then Bocardo relies on Batchelor and Kent County Council, but this was a case where the land had a ransom value, but it was a pre-existing ransom value, and it was a value which could be achieved in the market from persons other than the acquiring authority. The council put what might be described as a rather perverse argument, and that was that that value was extinguished because then the compensation would be assessed by reference to its scheme. But the short answer to that was no, because that value could be achieved from someone else. It's not the case here. In our case, any pre-existent value ceased to exist in 1934. It was lost, if there was any. It was lost by the earlier owner of the land. Bocardo did not acquire the land until 1974 and 1988.
Sorry, it was lost in 1934 because of the expropriation, not only of the petroleum, which had been done in 1918, but of the right to access it. Is this the point?
Any value that the land had, by reference to the existence of the oil reservoir, was taken from the landowner by the 1934 Act, which both nationalised the oil and conferred on the Crown the exclusive right to search and bore for and get petroleum. What the 1934 Act also did was set up a scheme for the exploitation of the petroleum by the grant of licenses in standard forms approved by Parliament. That is the scheme, and it is from that scheme that the landowner, Bocardo, seeks to derive its value. Without the scheme, it would not be able to claim an increase in its value or any value at all.
1934 rather than 1980. I mean, 1918 had already expropriated petroleum, hadn't it?
No.
Am I got wrong about that?
The 1918 Act simply required a person to obtain a license before they searched and bored for and got petroleum.
That didn't. I thought that put the oil gave the oil to the Crown. No.
No.
Oh, I'm sorry.
That was the first subsection, section 1, subsection 1 of the 1934 Act.
I see.
It both nationalised the oil and also at the same time.
I see.
Yes.
Sorry. Yeah.
Yes, I understood you to say yesterday that that's what it was. It was nationalisation plus the scheme for
Yes.
development.
Yes.
Sorry.
I mean, this is the critical point in the case, really, isn't it?
This, my lord, being.
Well, the role of the scheme. No scheme,
Yes.
the no scheme, no value point.
Yes. Yes, it is. Absolutely. And first of all, your lordships have to, if your lordships are with us so far, your lordships have to be satisfied that there is a scheme, and then identify the scheme. I think it was Lord Nichols in Waters said it's in some cases difficult to identify the scheme. That was what Waters was all about. What was the scheme? Was the wetlands part of the scheme or not? But in this case, in our submission, the scheme is quite clear. It's a scheme for the future development of the petroleum through licenses granted by the Crown. When you actually look at the licenses, if you have to go that far, you will see that the license is an exclusive license. To some extent, the fact that it's exclusive adds, if you like, to its value. So far as, if Bocardo was right, its ransom position was concerned. Because there is just one person in the market to exploit the petroleum, and that's the license holder. Assume that there was a sort of free-for-all, and anyone could drill for the oil, then the price that could be extracted from one particular person, the license holder in this case, who's under a duty, as you will see from the license, to drill efficiently and properly and so on, the price that that person, subject to the statutory responsibilities imposed by or the contractual responsibilities imposed by the license, the price that that person will pay may be greater than if, for example, anyone could start drilling it anywhere within the licensed area for petroleum in the reservoir without any responsibility to extract every last drop, for example. And so the value that Bocardo could get from this one particular person who is created by the scheme, given exclusive rights, but also subject to responsibilities by the license, the price that that person is going to pay is, in my submission, higher. And if the argument is right for Bocardo, they will get from that one person subject to these duties more than if, for example, a rival to Star could set up next door to Coney Hill and just go straight down without any need to extract, as I say, every last drop from the reservoir.
Now, I think we have to make some progress now. Any other cases that you want to take us to?
My Lord, Associated Portland Cement Manufacturers Application, 1966, 1 Chancery 308, Volume 3, Tabs 27. Perhaps I can just very briefly take your lordships to that.
Yes.
Tab 27 in Volume 3. Simply to say, first of all, that this was an application for the right to work the mineral. It wasn't an ancillary rights case. The mineral, therefore, had a value in the market, not just to the acquirer. And therefore, the observations that are made by Mr. Justice Buckley must be understood in that context. And I would just draw your attention to page 7. The applicants have at present no title to or interest in any of the brick earth on the site. What they're seeking is the right to go onto the site to win and remove the brick earth there. This is a property right of a kind which has been well known to the law for centuries, profit apprendre. Such a right may at common law be granted in perpetuity for a limited term. Whether the profit is the right to remove minerals from the soil, it involves the right for the grantee to acquire the ownership of part of the grantor's freehold, even though the right of working may be for a limited period only. It's not, I think, true to say that in the present case, the grant of the right which the applicant seeks will only deprive the respondents of the opportunity for a while to use parts of the surface of their land for agricultural purposes. There you can see what the argument was, and you can see how difficult that argument would have been. They will, by the extraction of the brick earth, be permanently deprived of a part of their existing freehold, which represents part of the value of that capital asset of their business. And I simply draw your attention to that case to demonstrate that it's a completely different case. Your Lordships, I know, have now clearly in mind the distinction that we seem to make, we make between a right to work minerals and ancillary rights. This was a right to work minerals. The mineral had a value of its own as a house, as I've said, would have a value in the market. And the question, therefore, was what value should be put on that asset? It's a completely different case again.
Yes.
I was then going to take your Lordships to BP and Ryder, but your Lordships have... I can just take your Lordships very briefly, BP and Ryder, and identify the passages on which we particularly rely. So your Lordships will find it in volume 3, tab 35. And the passages in particular that we rely on are in at 242 243D. I return to the 1934 and 1966 Act. I draw attention to the following points down to 244D, which make it perfectly clear, this was discussed on the first day, but it makes it perfectly clear in my submission that Mr. Justice Peter Gibson did apply the point guard principle. The judge at first instance in this case doubted that he did, but he quite obviously did do. And we also rely upon his summary of the effect of the authorities on page 246, H to J. Having considered all the authorities, but your Lordships, nearly all the authorities, more authorities than your Lordships considered, he says the effect of these authorities is to support the conclusion that consistently with the general principles applicable to compulsory acquisitions under the Land Clauses Act, 1, the grantor must receive consideration or compensation on the basis of the value of what he has lost, not on the basis of the value to the grantee of what he's acquiring. The value of the rights over land with its existing use and subject to its existing restrictions, together with all its potentialities, subject to not receiving more than he's lost, the landowner is entitled to compensation for disturbance and injurious affection. The existence of the scheme underlying the compulsory acquisition must be disregarded, but the presence in the market of a purchaser for whom the rights have a special value may be taken into account. The loss of the bargaining power of the landowner through the veto which he enjoyed until compulsory powers are invoked is not a factor to be taken into account. It is in our submission. That is a good summary of the position.
How do you give effect to 3?
By identifying some one else in the market for whom the rights or the land might have a special value.
How does that work here?
It doesn't work here. There is no one else in the market.
You mean, I'm not quite sure I follow that, but when the purchaser is whom? Somebody else apart from the promoter of the scheme?
Well, I've read it as being a third party. But if I'm wrong to read it that way, then we wouldn't agree with that.
Yeah.
One can say of Justice Peter Gibson's judgment, which is a very careful and thorough judgment, is that it may be that he didn't correctly apply the Indian case, or indeed the Cedar case, which he refers to, the Cedar Rapids case, at the bottom of 243. But in our submission, this at the end of the day makes no difference to the rationale. He may have, in fact, added too much on. He may have added an extra £5, which was unnecessary.
I mean, on your analysis, the £5 was wrong in principle.
Yes.
He should have stuck to the
40.
40.
Yes.
I mean, there's no justification on his analysis for the £5, is there?
Well,
What is it?
He says it's justified by...
This is the one more bid approach, isn't it?
Yes. Which in my submission is perhaps not correct. One doesn't.
Or put another
Let's
way
go that
wrong. Or put another way wrong.
Well, one could put it that way. But the essence of the judgment in my submission is right, and his analysis of the case of Safer, the Indian case in Cedar Rapids, is faultless.
Yes.
My Lords, we also invite you to, Lordships will read the Secretary of State's submissions, but we draw attention, if I can just ask your Lordships to note this, to the following paragraphs in relation to this 5 and 6, 35 to 37, 39.
Sorry, I've missed you. 5
5
and 6.
6.
Yes.
35 to 37, 39, 41 to 44, and 52 and 53. And if the Human Rights Act is an issue, whilst I'm doing this, paragraph 98 in particular.
Well, does that take us to trespass then? Does that take us to the trespass issue?
No, my Lord, it takes us to the pipelines.
Pipelines?
Yes.
Right.
And if I may, I'll try and deal with the Pipelines Act as quickly as I may. The Pipelines Act 1962, our submissions on this are set out in paragraphs 158 to 169 of the printed case. This was not a point that was taken before Mr. Justice Peter Smith, but it's a pure point of law. It was argued before the Court of Appeal. It was set out in the skeleton argument for the purposes of the hearing in the Court of Appeal. If one is looking for excuses as to why it wasn't raised specifically in the application for permission to appeal, I can only say that it was under pressure of time. Mr. Justice Peter Smith refused permission on the basis of no arguable point of law and no point of law of any interest, general interest. And my clients only had 14 days in the long vacation, judgment having been given on the 28th of July, to make their application. The judge limited them to 14 days. And the point was not taken. But it's just a point of law in my submission, for which...
The Court of Appeal deal with it in paragraphs what?
The Court of Appeal simply dealt with it in this way at the end of the judgment. really.
It was argued, we were told, de bene esse before the Court of Appeal.
Well, we certainly had a full argument on it.
And paragraph 121 just notes that there's no need to deal with it.
Yeah, because they reached the same conclusion based upon the on the 1966 Act. But the relevance of it is this: the hypothesis is that there is a negotiation. Exception to the general common law damages is a negotiation which takes place between the landowner and the licence holder. It's accepted on both sides that for the purposes of that negotiation, one must have regard to the statutory context. The statutory context will determine, in my submission, the amount that is agreed. The only disagreement between us is whether or not the Pipelines Act 1962 forms part of the statutory context. We say it plainly does, because this is a pipeline, as I'll demonstrate hopefully in a moment. And it's also quite clear that under the Pipelines Act 1962, no value is payable apart from compensation for any loss. This is absolutely clear in the case of the Pipelines Act 1962. Therefore, if it's a right to look at the Pipelines Act 1962, to some extent, these interesting questions on the 1934 Act and the 1966 Act don't arise, because the legislation, the Pipelines Act 1962, gives a right to compulsorily acquire the rights we seek, the licence holder was seeking, on this hypothesis, entitled to say that it was entitled to in the hypothetical negotiation. And it didn't need, therefore, to go under the 1966 Act at all. It's not a question of obtaining rights under both the 1966 Act and the 1962 Act. One would have done. It is, therefore, if the Pipelines Act 1962 is available, it's a shortcut and doesn't really have to trouble oneself with all the difficulties, if there are difficulties in construing Section 8.2 of the 1966 Act in the context of the 34 Act. The Pipelines Act is quite clear. Now you have the Pipelines Act in the bundle.
Poor Justice Aikins must have lost a lot of needless sleep.
Maybe.
Been a very simple preliminary issue, really.
It's volume 2, tab 15.
It is, yes, it's in tab 15. Now, we do have better versions of the Pipelines Act 1962, which I ought to hand up to your lordships at this stage. This is not a terribly helpful copy, the one that you have in tab 15. What we're handing up to your lordships, I'm afraid it's quite bulky.
It's just the
But the point and the provisions are few, and they should not take me long to explain.
Is this the Act in its original form?
You've got the Act in its original form and also in the form that it was in 1992. What you have in here is the form that it's in now. And what you're now being given is the Act in its 1992 form, is that right?
Yeah, it's agreed.
It's agreed with them. It's not the original.
No, it's 92.
Just right.
We have got the original if you want it.
Could I just also hand up to your lordship, because your lordships may find it easier just to look at the original Act, and then at some stage, if some point
This
arises.
is as at 1994, is it?
1992.
1992.
What I'm also handing up to your lordships is the Pipelines Act in its original form. It is. I'm doing this simply because it's much easier, my submission, to read it in this form, the original form, the old-fashioned form, than it is in this new, modern internet form. So if I may, then if your Lordships want to cross-check to the form it was in 1992, if I may, I'll use the Pipelines Act 1962 in the original form. By looking at it, your Lordships can see, first of all, and this arises out of an exchange that took place yesterday, that the first 8 provisions are concerned with, in fact, cross-country pipelines. We're not concerned here with cross-country pipeline. It's just an ordinary, everyday pipeline. And then if you turn to section 11, you will see that section 11 confers on a person proposing to execute works in land for the placing therein of a pipeline or length of a pipeline. That person may obtain from the minister a compulsory purchase order of land. And then you will see in subsection 3 a reference to the second schedule that sets out the procedure. There will be some form of advertisement, and if the minister thinks fit, there may or may not be a public inquiry. But 4, the provisions of the third schedule to this Act shall apply to a compulsory purchase order. And if you then turn to the third schedule, you'll see it's at page 1255. That in relation to a compulsory purchase order, the Lands Clauses Acts are hereby incorporated with this Act. Of course, there's therefore no doubt about section 63 in value here, but this is not, as I explained, the most relevant section, with the exception of the following provisions of the Land Clauses Consolidation Act 1845, and there's some amendment to them. And then there's another consequential provision. You haven't seen paragraph 1 and paragraph 2 before, because it's not in the Act anymore, but this is as it was originally. So there was an incorporation of the Land Clauses Act in order to determine compensation. If I can ask you...
Which Act is that, the Land Clauses Act?
The Land Clauses Act is a definition given by the Interpretation Act 1979 to the Land Clauses Act of the Land Clauses Consolidation Act 1845 to 1895. So it's a term which one will find in the Interpretation Act, and it covers all the 19th century legislation beginning in 1845 and ending in 1895. But more relevantly, section 12. Section 12.1, a person proposing to execute works in land for the placing therein of a pipeline or a length of a pipeline may, by means of an order made by the minister, a compulsory rights order, be authorised subject to any conditions attached thereto under the next following section to place the line or length in land described in the order, to use the line or length to execute in that land any other pipeline works. I just emphasise at this moment, and I explain why, any other pipeline works becoming necessary for the purpose of placing the line or length in that land, or in consequence of it being placed therein, and to exercise in relation to the line or length such of the rights mentioned in the fourth schedule to this Act as may be specified in the order. And then again, compulsory purchase procedure. And then if I could ask you to turn to section 14, I haven't seen before. Section 14.1, it's on page 1963. If a person entitled to an interest in land which comprises or is held with land to which a compulsory rights order applies, being an interest subsisting at the time when the order was made, proves that the value of his interest is depreciated by reason of the making of the order, the person in whose favour the order was made shall pay him compensation. And then there's a question of loss. So that's the compensation provision in relation to compulsory rights order. It is just pure compensation. No element of value there. it would be very odd indeed if one could get, so to speak, a ransom value when there's a compulsory rights order under Section 12, but not get one where there's a compulsory purchase order under Section 11. Passing on, I ask you to note Section 57. It's not part of my argument, but it has been referred to.
Section?
It is Section 57. It is referred to in the written cases. The reference in paragraph B of subsection 2 of section 3 to conveyance of minerals shall be construed as not including a conveyance by means of a pipe. And then, yes, I should say that. That was in the original legislation, but it was repealed.
Are you going to take us to section 65?
Yes, but section 57 was repealed by the Mines, Working Facilities and Support Act 1966. I'm now going to take you to section 65, that's pipeline. And it means a pipe for the conveyance of anything other than air, water, and so on. In my submission, this is plainly what we have here are plainly pipes for the conveyance of petroleum. Of course, one of the pipes is for the conveyance of water, but that is brought in by subsection 2 of section 65. And then you'll see in section 66, there are some definitions. And if I can just take you to pipeline works. And remind you that a compulsory rights order would include a right to carry out pipeline works. Means works of any of the following kinds, as say placing a pipeline or length of pipeline, inspecting, maintaining, adjusting, repairing, altering or renewing a pipeline or length of pipeline, changing the position of a pipeline or length of pipeline, and then B, breaking up or opening land for the purposes of works mentioned in the foregoing paragraph, and tunnelling or boring for those purposes, and other works requisite for or incidental to those purposes. So, if I can just ask you to turn to our case. And paragraph 162.
162.
162.
Okay.
Although Bocardo is now unwilling to use the expressions pipeline, this was the purpose of the agreed statement of facts, so I couldn't agree it. Nonetheless, in its amended particulars of claims, it used the pipework and the further pipework as defined terms in relation to the pipework from the wellheads. Bocardo's own expert evidence at trial was that steel pipe was used to case the well during the drilling process, and that if the well is to be tested or produced, reduction tubing is placed within the casing. Mr. Justice Peter Smith referred to its pipes and pipelines in its skeleton argument of pipework. Court Appeal referred to them as pipelines. Bocardo, in its petition for leave, referred them as pipes and pipeworks, and there are other references to them being pipes. And for example, Mr. Crawford, who was Bocardo's expert, in his report, which is in the appendix part 2, at page 203, paragraph 12, said that the wells he said that in layman's terms, these wells are pipes which run from the estate, which run under the estate from the wellhead site. And then, in layman's terms, these wells are pipes. They are pipes, the purpose of which is to convey petroleum from the reservoir up to the surface, and then what can happen, in some cases, it happens at Witch Farm, for example, the oil is then stored the crude oil is then stored and then transported out by means of other pipes. So crude oil comes up from the reservoir to the surface, and then from the surface it can be piped. You've heard that in our case it's trucked. It can be piped somewhere else.
So I think initially one has to drill down in order to get to the apex. Is that right? But that's all part of the pipeline works as defined. And,
Yes.
and so the fact that initially you're drilling down and not conveying anything up doesn't defeat the idea that this is essentially a pipeline.
No.
Is that your
That's
position?
right,
Because ultimately the same route will be used to convey from the apex to the surface what it is that you're seeking to get.
Mr. Gaughan said that the drilling down wasn't covered, but in my submission is wrong in that, because the drilling down is covered by the word pipeline works, and the Section 12 gives one the right to acquire the right to carry out, amongst other things, pipeline work. So it's all part and parcel of the pipeline. It's the works preparatory to using the pipeline for the purposes of conveying petroleum. You've got to bore it first of all, and the word bore does appear in the definition of pipeline works. You have to drill first of all in order to put your pipe in.
Yes.
And your exploratory pipe, of course, one reason why you're boring into the reservoir is in order, even on an exploratory basis, to see what's there and what you can get out of the reservoir.
Well, we're given a description in paragraph 9 of the Statement of Facts and Issues of these. They're described as wells, I think. Is that right? PW is a reference to wells, and it's casing of a kind with tubing, which serves a dual function. Initially accommodating the drilling bit and all the rest of it that has to get down to the point where the oil is, and then it serves, the same casing serves to maintain the tubing for it to be brought to the surface.
Yes.
And I think, am I right in thinking that it's all part of the same route? It's not as if there are two parallel things, one for drilling only and one for conveying only.
No. Your Lordship is right, yes. They're called wells there because we weren't able to agree on the use of the word pipes, but the wells were lined with steel casing with tubing inserted. And originally an exploratory, as you can see in 13, PW5 was first drilled as an exploration well, and then it was used for production purposes. It's the same.
And does PW stand for Palmer's Wood, or
Yes.
or for? That's what the acronym is.
Yes, it is. Yes,
Mr. Ryan,
Lordship's right. I'm afraid I hadn't done it on me, but
glancing at the 1998 Act, the Consolidating Act, and I mean, you know, when you look at ancillary rights under that, Section 7, I mean, I just wondered whether that referred to the Pipelines Act, but of course it doesn't. It refers to the Mines 1966 legislation.
yes.
I mean, why wouldn't it refer to this Act? If you can do it all under this Act.
Well, you can't. That may be the answer. You can't do it all under this Act. That was the problem in BP and Ryder.
Well, this was the preliminary point of Mr. Warner.
And there are rights that you might need in addition to actually drilling into the reservoir and then piping it out. You need, in that case, you need to lay roads and you need to provide other pieces of infrastructure. In that case, I think a gathering station. In many cases, you would need to be able to carry out more works than simply pipeline works. And so it was thought, this was the reasoning of Mr. Justice Warner, it was thought sensible that you could apply for all those rights, not just pipeline rights, under one piece of legislation.
But it might have envisaged it, mightn't it? I mean, in a case, you say, like this case, where you don't need anything else but pipeline powers, I mean, why wouldn't the Act have mentioned it? An oversight of parliamentary counsel.
But if what we're doing here is we're construing the 1962 Act.
Could it be? I mean, I'm purely suggesting, but there could be cases where you bore and you can't actually achieve anything because it's been searching for something which, when you get down to the relevant depth, isn't actually obtainable. Now, that wouldn't be a pipeline, would it? Because it's simply going, it's a bore. It's not conveying anything. At least it's certainly not conveying oil unless you can actually put it in the correct direction to get the oil out. Is it possible that because of that difficulty in searching as well as actually getting, that the 34 Act is wider than the 62 Act?
Well, possibly, but I would just take you to the definition of pipeline works, which includes breaking up or opening land for the purposes of works mentioned in the foregoing paragraph, and tunnelling or boring for those works, and other works requisite for or incidental to those purposes. You will drill your pipe into the reservoir in the hope that as a result of it, it will produce some oil. And indeed, you will know that there is a reservoir of oil there, not from your drilling, but from the seismic tests you will have carried out before drilling. Seismic tests will show you whether or not there's oil there. And so, on the basis of those tests, you will put your pipe into the oil field in the expectation that you'll be able to extract oil through it.
So, but in practice, you'd need ancillary rights under the other statutes, would you? In this case?
In this case, no, they wouldn't. Not in this case, because the only
you wouldn't need any ancillary rights.
No. The argument in BP and Ryder before Mr. Justice Warner was that the Secretary of State said that insofar as they were pipelines, the Secretary of State was not suggesting that the well itself, if I can use that word, I don't mean to draw a distinction, was itself a pipeline, but insofar as we were seeking, BP was seeking, I should say, rights to convey the petroleum off-site, that those, or around the site, that those were pipelines and therefore fell within the 1962 Act. But it was never suggested that it's either or, in the sense that if it's a well which falls within the 1966 Act, as amended by the 1934 Act, it can't therefore also be a pipeline for the purposes of the 1962 Act.
But is it not right to remind ourselves, we're looking at all these statutes, actually we're talking about damages for the tort of trespass. And do we really have to, is it really right to suppose, if an application had been made, that your clients would have applied told Bocardo that they were going to do this under the Pipelines Act rather than under the Act which obviously applies? You'd have immediately landed in litigation on that, wouldn't you, in this hypothetical situation?
Well, my Lord, I wonder if that is the right approach to it. First of all, in my submission, the Pipelines Act 1962 does obviously apply, and for the purposes of...
Does obviously
well, there it is. Well, your Lordship's now been taken to it. It's not suggested it's not a pipe or pipeline. It's suggested that it's not a conveyance of petroleum, conveyance of matter. But surely the court, in deciding how the hypothetical negotiation would have gone, should not indulge in, as Mr. Justice Peter Smith did, some sort of speculation as to whether or not, in his case, BP and Ryder was right or not, or whether or not the Pipelines Act 1962 would apply to the pipe. The court must surely decide whether or not this pipe was within the meaning of the Pipelines Act 1962, yes or no, and then in that context, decide how the hypothetical negotiation would have gone. It can't say, well, it might have just invited some litigation, as indeed BP and Ryder might have invited some litigation. One of our criticisms of Mr. Justice Peter Smith's approach to this was that there he was, a judge, speculating on whether another judge had got a decision right or wrong, and just saying, well, it would be left that the parties would mark, if you like, Mr. Justice Peter Gibson out of 10, and the uncertainty in the law would be programmed into the negotiation. In my submission, that can't be the right approach for a court when it comes to the hypothetical negotiation or exceptions to the general rule. The court is there to decide, in my submission in relation to this, whether or not the Pipelines Act 1962 applied and was available to the licence holder. And if it was, then the court decides how that would impact on the negotiation.
Well, is there anything more in the Act that we need to look at?
No.
Because I'm concerned about timing
Yes.
now, and I think we really should move on to trespass unless there's anything more you want to say.
No. I've said everything so far as the Pipelines Act is concerned. Can I now then deal with the point that we make at paragraphs 105 to 110 and deal with it very shortly? It's explained there. This is now coming back to where this all takes us.
Yeah.
And the general principle for an award of damages is, common law, is that the claimant is compensated for its loss. There is an exception to the general principle in what's called wayleave cases, trespass to land cases, where the trespasser makes a gain from the trespass. But if we stand back now, and I ask you to assume for this purpose that we're right, and that the statutes which set up the context for this hypothetical negotiation are statutes which would enable my clients to acquire rights compulsorily on the basis of a payment of compensation to the landowner, which simply reflects its loss, which is non-existent. Then my submission to your lordships is that in that case there is absolutely no sense in departing from the general principle on which damages are assessed. We are concerned here with an exception. And the question is whether or not the law needs to make an exception in a case of trespass where, had the trespasser acted in accordance with its statutory rights, it could have acquired lawfully at no payment to the landowner, in reality, the right to make the use which gives rise to the trespass.
But you're actually saying that they should be held by the law to be better off for having trespass.
Well, my Lord...
Not better off by much, of course, if the rest of your case is right,
Yes.
but better off.
Well, my Lord, I see obviously what your Lordship is saying, but no, in my submission, they would not, in my submission, be better off. If they had gone through the statutory procedures, then if we're right, the amount of compensation payable to payable to the landowner in this case would have been nil. And we've just been looking at the Pipelines Act 1962.
But that's a different point.
No, but they're not better off, as it's put by the court saying that the general principle for the assessment of damages should apply. There is a trespass. That may well lead to an award of nominal damages under the general principle rather than the exception. They're not, in my submission, better off in terms of what they have to pay a claimant if they went under the statutory compulsory acquisition procedures, because using those procedures, the claimant would not have been entitled to payment anywhere. Lord Justice Atkins, this is the point that your Lordship, my Lord Brown, is making, is the point that concerned Lord Justice Atkins, and that was that in some way or another the trespasser is better off. We do make the point, well, there's hardly anything in it, but the principle for the assessment of common law damages is that the claimant is compensated for its loss. There is then an exception. Where the exception leads, as this long analysis of the cases in our submission does lead, is that the landowner is compensated for his loss. It's the same test. And the damages that will be awarded at common law are the same as, and no less than, the compensation that would be payable to the claimant had the compulsory acquisition procedures been used. So why is it necessary to go down the route of imagining a hypothetical negotiation which takes place against, I'll ask you to assume that we're right, in the context of legislation that would enable the oil company to obtain the right lawfully without payment of any compensation? Why is the court concerned in such a case not to apply the general principle? It's not the function of the common law to punish a trespasser. It's the function of the common law to compensate the claimant. And if at the end of the day we could have obtained the same right lawfully without making any payment for the use to the claimant, then why should we consider the exception at all? This was considered by the Court of Appeal, and Lord Justice Atkins found that there was some attraction in it. It's paragraphs 89 to 92 of his judgment. And perhaps I can just ask you briefly to just to see how he puts it. And it's 89 to 92. I ought to say, perhaps, or maybe I oughtn't to say, but I will say that this argument was one which was initially suggested by the Court of Appeal themselves rather than by counsel for either party. But having been raised by the Court of Appeal, they then...
That's probably the only reason they were reluctant to dismiss it.
It's paragraph 92. I've concluded this would not be right because it would mean that Star would be in a better position by committing the technical trespass that it has rather than obtaining agreement or the ancillary right to bore the pipelines that I concluded that it should have done. In my submission, this is not correct. What the court has to decide is whether or not it is fair to resort or consider an exception to the general rule or not. The general rule is you're simply compensated for your loss. That is exactly the same principle, in fact, as one finds under the compulsory acquisition legislation, we say. And if we're right, why has the court decided to investigate what would be payable on a way-leave basis? Why not just simply stick to the general principle, the general rule? Anyway, that is that's our case. If it said, well, it saves you a lot of fuss and bother, it saves you the hassle factor, as we've described it, then in my submission, the criticism of that is twofold. First, it is not compensating the landowner for the profit derived from the use of the land. It is compensating the landowner for not being unreasonable and requiring us to obtain the statutory rights rather than giving them to us by negotiation. The point is explained in our submissions, but I do ask your lordships to consider, bearing in mind that the court is not here to punish a trespasser, whether or not at the end of the day, in a case such as this, if you're right, if your lordships accept our case, whether or not it is an appropriate case where there is a compulsory purchase power, compulsory acquisition power, to go through the hoops of considering a hypothetical negotiation.
Well, I think the point is quite shortly put then. I mean, we've got it written out, paragraphs 105 to 110, and we can see what the Court of Appeal did with it.
I was then going to deal with the human rights point. Well,
I'm not sure their lordships are really need you to go into that, frankly. Do you?
Well, I'm speaking for myself. I would like to know what you say about the out of time point, and, the suggestion that it doesn't apply at all because the trespass occurred before the act came into force.
Our submissions on this are in paragraphs 170 to 184. One of the cases that we don't refer to there, but which your lordships have been taken to, is Pell Frischman. I'm not asking your lordships to look it up now, but it's in volume 6, tab 75, and we rely in particular upon paragraph 50, where my Lord Walker cites with approval a passage in the judgment of Lord Justice Neuberger in Lund Poly. The agreed exercise between the parties, so far as way-leave damages is concerned, is to determine what would have been agreed, subject to all the submissions I made, what would have been agreed between reasonable persons as a reasonable price or a reasonable sum to pay for the right which gives rise to the user. It's agreed between both the parties that this hypothetical negotiation would have taken place before the wells were drilled, or at any rate before 1994, at any rate before 1998. The claimant is not asking for damages on the basis of, let's say, the general principle, loss to itself from 2000 onwards, but on the basis of an exception to the general principle, which itself is based upon a hypothetical negotiation which would have taken place before the enactment of the Human Rights Act 1998. It therefore seems illogical, in the same way as it's illogical to consider the negotiation in the context of the Petroleum Act 1998. to look at that hypothetical negotiation which took place before 1994 by reference to legislation which did not then exist. If they had been asking for damages based upon their loss after the year 2000, and there might be something in what they say, but because it's based upon, this is the way they put it, a hypothetical negotiation which took place, as they accept, before 1998, it seems absurd, quite frankly, to bring into account the legislation which did not then exist. In the same way, Lord Justice Neuberger in Lon Polly, referred to in Pell Fishman, paragraph 50, said that for the purposes of the hypothetical negotiation, you don't take into account events which occurred subsequently. Well, the Human Rights Act 1998 was a subsequent event.
I mean, I think really what they say is, all right, well, we'll forget, because actually their statute barred up to July 2000, so we'll forget even, Mr. Beloff generously waived July to the 2nd of October, and say, you know, well, we'll just complain, therefore, of the trespass from then on. I mean, it may be recasting the case somewhat.
Well, it is recasting the
well,
case.
maybe it is, but it's...
but
what about that? I mean, let's just take that case.
Well, the cause of action accrued in 1986.
But I thought trespass is a continuing.
Well, no, but the assumption is of a hypothetical negotiation which took place, it's the nature of their case, before the trespass, in this case, commenced. If one then is then considering a hypothetical negotiation in 2000?
Well, I think that's the way it would be put.
Then the whole of the evidence would have to be looked at again to see what the parties would have agreed in the year 2000. It has to be borne in mind that the best years of this occurred are behind it, and we're behind it by the year 2000.
If the only impact of the convention were in relation to construction of Section 8.2, that surely would be taken into account, because even before 1998, legislation had to be construed in accordance with the United Kingdom's international obligations.
I'm not sure about that.
No, in fact, your Lordship may be right. I'm not saying your Lordship's not right, but I don't think I can sensibly answer that. It does come as a bit of a surprise to me, I think, is why I can't answer it.
But in any event, even if it were a question of the Act, all that's happening is that the court is construing, even now, the correct meaning of the Act.
Yes.
And that would be declaratory, wouldn't it? It wouldn't have changed its meaning.
Well, my Lord, one shouldn't, in my submission, lose sight of why we're doing this. What the court is doing is assuming how a hypothetical negotiation would have gone. It then has to decide, surely, when that hypothetical negotiation took place. And it's been agreed between the parties, we make several references to it, and it's in the agreed statement of facts, that the hypothetical negotiation would have taken place before, well before, in fact, the Human Rights Act 1998.
So you say it would be their then understanding of what the legislation meant?
Yes. No, not their understanding, but what the legislation then was. Yes. The court's construction of what the legislation would then have been.
You can't Section 3 it retrospectively, that's for sure.
The only way in which one might be able to bring it into play, you then have other problems as to whether or not there is a contravention of Article 1, Protocol 1. is by, so to speak, postponing the date of the hypothetical negotiation. Parties have always proceeded on the basis of a particular date or moment, the moment being before the pipes were drilled, for that negotiation.
Well, in his written case, I think it's fair to say Mr. Beloff puts it firmly within the period 2000 to 2007, because he's taking advantage of the statute. He's not relying on any pre-existing
No, but the whole case
about this, as I understand it.
Yes, but the whole case is...
We've reached 1 o'clock, Mr.
Yes.
Driscoll. I think we're going to have to ask you to accelerate very, very considerably, because we've got to rise at 4 o'clock promptly. And Mr. Gaunt has to have an opportunity to reply. It may be that Mr. Beloff has too, and you haven't even begun your trespass chapter, which occupies quite a lot of pages in your written case. Is it unrealistic to expect you to finish at 3 o'clock?
No.
So that people can reply to you? I don't know whether you need as long as an hour, do you, between you to reply?
I don't think for my part I need as long as...
Well, perhaps you could discuss with each other, but you need to have a target point at which you finish, Mr. Driscoll, because there has to be time for a reply. Can we leave it to discuss between yourselves, and perhaps you'd be kind enough to tell us before we start the argument in the afternoon what the timetable is?
Oh, yes.
All right?
Yes.
2 o'clock then.